Шановні колеги, продовжуємо.
Dear colleagues, we continue working in the Ukrainian Crisis Media Center, and current our topic is correction of justice mistakes as a need in reforming the judiciary system. We have Mykhailo Zhernakov, Mr. Oleh Levytskyi, and Andrii Didenko. And via Skype, we will have Mr. Svanidze, expert of the Council of Europe. And a bit later, Mr. Viktor Shyshkin, former judge of the Constitutional Court of Ukraine, will join us. Good morning, dear friends. Thank you for attending this press briefing. For me, it's a big honor to be here today, and because I think it's the topic of primary importance. I understand the reasons, but for me it's not clear why we still tolerate that bad situation with the human rights of accused offenders. The civilized society, modern civilized society, is based on the human rights, and when we speak about criminal law, it also should be based on the human rights. For me, it's not clear that even now in Ukraine, people are punished and remain in the penitentiary institutions for the crimes that they have not committed. Being the expert of the reanimation package of reform, I understand clearly that fair court and fair justice could not be existent without a mechanism that people, those who were accused, in line with the extremely obsolete criminal and procedural code, which is 57 years old, that those people could not be granted the proper mechanism for correction of that justice miscarriages. The draft law number 2033 about correction of the justice miscarriages remains without any movement in the parliament. Why it does not move? This is the militia lobby, the police lobby, which remains in the parliament. Then some political games played by political factions. And now they keep saying that if we liberate these people from the penitentiary institutions, this will make harm to the interests of the police lobby. I would like to make a statement that we cannot call ourselves a democratic country if we continue to put the police lobby interests before the interests of the human rights and freedom of those people who remain in penitentiary institutions for the crimes and deeds that they had not committed. All our attempts to point out to this draft law and to draw attention of the MPs to this draft law, they were in vain. We did not succeed in promoting this draft law. We suggested to create working group. We suggested to review the draft law in a parliamentary committee, but nothing changed. I would like to emphasize once again, we cannot call ourselves a civilized country or a country striving to be civilized unless we have passed the bill number 2033A about correction of the miscarriages of justice. Thank you. I'm Andrii Didenko from Kharkiv Human Rights Group. I would like to remind you how that bill was drafted back in 2012. After Partnov's justice reform, the Supreme Court was deprived from the revision of the criminal cases, and people who were accused had no practical opportunity to approach to justice system and to review the case. Those people who criticize the bill number 2033A say that we have the mechanism in place, but all the law advisors to the accused people and to sentenced people, they know that this mechanism is very bad, that in our practice, in the practice of Kharkiv Human Rights Group, we have a big number of cases of people who were accused in line with the Soviet criminal and procedure code, and they have no opportunity to submit for review of their cases. Alexander Rafalsky for many years tried to receive fair justice and finally died in prison. Zhernakov, Ahmet Ibrahimovich, who were accused by Sevastopol city court, this person never visited Sevastopol. Lyubov Kushinska, who remains in jail. She is 20-year-old and she remains in penitentiary institution and has no possibility to apply for revision of her case. All those people who try to get fair justice for their children, their relatives and families now do not trust in fair justice. We won't go to Europe without this possibility for fair justice in Ukraine. Those people were accused in line with old Soviet criminal and procedural court. They had no right for appeal. They were accused in the court of the first instance. Now we have Viktor Shyshkin, ex-judge of the Constitutional Court of Ukraine. Thank you for giving me the floor and for invitation to this press briefing. Of That's right that errors of justice had been happened, is happening, and will happen in the future, because homines est rara, and this is the nature of a human being, and judges are the human beings. They're subject to mistakes, but the only issue is how to minimize the errors of justice. In many countries, they try to provide proper mechanisms. The errors of justice are possible in administrative and civil, in criminal law. Much is said about the judges reform or the justice reform. I think that there is not the justice reform. I think that the first stage of justice reform was in 2001, when we allowed European right of appeal and European right of cassation, and that's it. The process which is going now, this is the primitive attempt. Now let us think whether we made any organizational steps towards review of the case. In the past, the Supreme Court had the right to review cases after cassation based on the judgment, based on the ruling of the European Court of Human Rights. Then the contradiction in the rulings of different cassation instances. But in the year 2010 or 2012, the law by Mr. Kivala was passed. There's two reasons for review of cases which I mentioned. They were universal for all laws, while in the commercial court there were three. There were three reasons for review of cases. In criminal law, there was four reasons for review of cases. Thus, in the old system, this was very much similar to the old Soviet system. In that time, everything depended on judges, and the judges could make the decision that the case should be revised. In one of my separate opinions as a judge of the Constitutional Court, I wrote that what should be the grounds for decision to review the case. Five judges had to uh, agree about the revision of the case. There were 50 members of all the chambers in the Supreme Court, and out of that, more than 50 members, at least 5 judges, could be united together to recognize that any case requires a revision. And now all this system is demolished. We do not have it in place anymore. Dear colleagues, when we come back to the draft law 2033A, the drafters of this law applied to the Council of Europe and requested opinion from the European experts about this draft law. And today via Skype we have Mr. Eric Svanidze, expert of the Council of Europe, who would like to comment on this draft law. Good afternoon. Although I did not discuss the language of my presentation, unfortunately I cannot speak Ukrainian, and I do not wish to speak English. If you allow me, I will speak Russian in this Can you hear us? Good afternoon, ladies and gentlemen, dear colleagues. Unfortunately, I could not join you for this important discussion. My time for Skype, I have an opportunity to speak via Skype. I do not think that there is any need to emphasize why this draft law is necessary. The explanatory note to this draft law explains this need, but I would like to emphasize the unique nature of this draft law. The draft law is dealing with the systemic shortcomings of Ukrainian justice system. In many jurisdictions, similar mechanisms were developed for rehabilitation and correction of the errors or abuse of justice for political reasons, and that mechanisms which had to counteract the political misjustice, they worked in many jurisdictions. But with my colleagues, we reviewed the this draft law which passed the first reading, we assessed it. This is an important mechanism that should be provided, but we have to emphasize that there is no international obligation for the states, for the countries to introduce such a mechanism at the national level. This is not the obligation of the state to review the court sentence and court decision. But I personally believe, and Mr. McBride, he joined me, that in Ukraine there is the real need to introduce such a mechanism. What is the specificity of Ukrainian mechanism? Well, in other jurisdictions, the revision of court verdicts was the was in the powers of prosecutor's office or special commissions. In Ukraine, the participants of the parties of this mechanism will have the right to apply to the judiciary bodies. And I think that I think that the specificities of your mechanism, they come from the specificities of your system. Unfortunately, I had no possibility to review the draft law before the second reading. So I believe that direct access to justice for those people who were accused for crimes, this is the right thing. We had doubts about a limited scope of the law, about the categories of convicts, and I think that again, Ukrainian realities forced you to limit the scope of the law application. At the same time, I would like to emphasize the concept specificity of this very draft law. Although you offer narrow base, narrow scope for the law, but you offer the formal features for revision of court verdicts. What do I mean? The European Convention and the European Court of Human Rights practice suggests that not all the formal pretexts, the formal reasons for revision of the case Some of them are of just formal nature, which might be nevertheless based on the considerable violation of human rights. These formal causes also could entail essential violation of human right to fair court. What do I mean? For example, the verification of witnesses, the verification of the witnesses received from interested witnesses, and such reason as distorted circumstances. I think that those reasons may provide quite broad preconditions for the revision of case. Suggesting these reasons, you set higher standards for the revision of cases. The more liberal approach taken by the European Court of Human Rights does not provide that all the final verdicts should be revised. The European Court of Human Rights provides as the reasons only the cruel treatment or the cruel violation of the right for fair justice. All those reasons are available on the website of the Council of Europe. We analyzed everything in your draft law, and I would like to emphasize an important thing. When you limit your availability of justice with only those persons who committed a felony, and at the same time offering the rather broad list of pretexts for revision of cases, this may result in cancellation of some, in repeal of some verdicts. You might review even the cases which won't be classified as violation of Article 6 in the European Court of Human Rights. Maybe you should clearly define the scope where this revision mechanism could be applied. In this or that way, the mechanism should be in place. It's up to you how to design it. But when it comes to European Convention, to Protocol 7, to Article 3 of the European Convention, such a mechanism is necessary, and if you launch such a mechanism, the court mistake will be approved, then you need to provide compensational measures, the measures for compensation of the court mistake. And this should be clearly defined in this draft law. So the main issue which remains unclear for me and which we would like to bring to your attention, that your draft law will not comply with the European Convention, is the absence of the compensation measures in case of the court mistakes. I think that I've taken too much your time. Thank you very much for your attention. So I would like to sum up. I would advise you to think about possibility to cover with this mechanism the persons who had committed felony or who were punished for the felony. And restitute their rights via compensation in that number. Then more clearly think about the preconditions for case revision, and think about compensation provisions. Then you will find, I think that practice could be easily found in Ukraine and in the European Court of Human Rights. And one more nuance. I have not seen yet in the new draft law. Your draft law does not cover the medical measures that is a medical definition of the mental disability of the victims. Thank you very much for your comments, and now we give the floor to Oleh Levytskyi.
Good afternoon. So you heard my colleagues, and I listened to them with great interest. Eric, Svanidze, important issues were raised. And adoption and implementation of this document 2033A is important, and I won't repeat what my colleague said. We don't have time for this. I would like to say that as a lawyer, as a person, I would like to say, let's imagine that in our country from 2010, we do not have a mechanism for reviewing the convictions in criminal cases. There is no such a mechanism for a person who was convicted on the grounds of some evidence of some creatures from Mars, for example. So it is difficult to appeal against these decisions of court, and we have new Supreme Court, new people in the government and law enforcement bodies. We see this conviction of previous times, and we say sorry that it happened. Panasenko, Vladimir Ivanovich Panasenko, was convicted on the grounds of evidence provided by a person who was arrested and was released from a mental institution. And this person was drinking heavily for many years, and he is even first this person named another person who ordered the crime, and then this person provided another evidence about other person, and then on the third day this person said that Panasenko was, and in the court, when this person became a normal person, he went out of this state that he was in for many years, and first the investigators said to name one person, then to name another person. Then he said that neither of this person could do that. That's why you should name third person. So this is the problem. In our country, there is no mechanism of reviewing the cases. And Panasenko case and other cases, when people are convicted, and the grounds are poor for convictions of such people. So the evidence is so vague, and they are like from Mars. And for many years, we say that we can not feel free, and we cannot be calm when we understand that there are many people convicted because of false or accusations or lack of grounds for conviction, and this situation should be resolved. Thank you. Now, if you have questions, please raise your hands, introduce yourself, and ask. We have several minutes for questions. That's why be brief. Do you have questions? I have a question. Please introduce yourself. Good afternoon. Vladimir, I'm from Kharkiv. I have a question to Sergei. Tell us, please. We had corrupted police. Then it was dismantled. Then there was Svanidze. He resigned, and a person who is in prison for 20 years is still in prison. It happened so. I saw a woman on TV, and I know this woman, and I can provide the evidence. We have lie detectors. I went to Lviv to the lawyer. This woman did not commit any crime. I speak about Levytskyi. I provided evidence to lawyers. And what should I do next? And she is still in prison, and this is for 20 years. If you ask me, you shouldn't say, I'm the constitutional court judge, not the common judiciary system judge. And we analyzed the matter. We should find the way out of the situation. Yes, you are right, but there is an issue. Who should do this? This case should be reviewed, or a new case should be opened by police against those who provided false evidence. If a person was convicted grounded on some false accusations. So this should be done by law enforcement bodies, not by the courts, because judges cannot start proceedings. And Article 97 provides the right to the court to start the proceedings, but now we do not have such rights. So if we reduce it to a court system, so we make mistakes. Please remember the document. Everyone forgot about it in the government and in president office. It was called Court and Judiciary Reform. And this was the provision about court and judiciary reform concept. So the reform should have been provided to court, judiciary, and extrajudiciary sphere. And so who are those people who initiated the court reform? Did they found pluses and minuses, whether it was done or not? And who cancelled the provision of the Supreme Council of 1997? Why don't they observe it? And 90% of your questions are connected with the previous activity of the prosecutor's office or the police, because the court is the final stage and they cannot intervene into investigation. And in procedural system, the court, it should be impartial, and people should carry out their functions appropriately. Avakov, Lutsenko, do they do it correctly? Do they really implement their functions correctly? Court should be impartial. And you remember about Marxism. So, despite ideology, so if you solve some small problems, some minor problems, they cannot solve big problems. So people just try to solve problems, and they just imitate court reform. So you said about Strasbourg court. An expert said about Strasbourg court. And what about the reforms? When can you address the Strasbourg court? It is constitutional complaint. You can open Article 151. You can address international institutions after you address national institutions. But this is not for constitutional justice. Why should you undergo all these court procedures if they do not assess the document concerning constitutionality? So there are many problems, and everything starts from political power. Judiciary and prosecutors' offices, they are formed by politicians, by political power. We do not have time for questions. We can continue our discussion off records, and we hope that we will be able to change the situation for the better. Thank you.